Hi. So, what I'm going to be talking about today, can you all hear me? What I'm going to be talking about today is not discrimination which takes place in the workplace, but something a little different. And what I'm interested in is situations where employees engage in off duty speech. Usually, the off duty speech takes place on social media, but not always. And then it is offensive in a way that impacts the workplace. And I'm interested in both anti Semitic speech and speech about Israel. Now, this issue comes up in two separate ways. So, first, there have been cases where employees have been penalized for posting anti Zionist or anti Semitic speech, the kind of speech that many of us would find appalling. So, for example, there was a well known case. There was a woman, Janan Shahadi. She was a Muslim Arab, and she had been offered a job at a large law firm in New York City at Foley and Lardner, and her job offer was rescinded because of posts like the two that I put up there. First, on October 7th, she wrote, "If you support Palestine, understand this necessitates supporting our right to defend ourselves and liberate our homeland by any means necessary. You cannot claim to stand with Palestine if you prefer us to be slaughtered without fighting back." And then she doubled down, as you could read up there, a few days later on October 11th. So certainly this seems like this was somebody who was condoning terrorism. There was a big outroar about it, and as a result, her job offer was rescinded. On the other hand, you have situations where employees are penalized for their pro Israel speech that they post on social media. So, one case involved Dr. Benjamin Neal. He's a cancer researcher at NYU. Now, while he didn't lose his entire job, what happened was he had a very lucrative contract to run a cancer center, and that contract was rescinded because he posted or reposted different cartoons, different, something like what I showed you up here, which are basically satire about people who had celebrated or who marginalized Israeli suffering. And he argued that because Zionism was an integral part of his Jewish identity, it was anti Semitic or religious discrimination to punish him for this type of a post. So, what I'm looking at now, full disclosure, this is a work in progress, is how we should think about this type of speech that takes place out of the workplace. Now, before I let you know what some of the laws are in the United States that cover this, I just want to give some background information since I don't know how familiar you are with the American legal system. In the United States, we have something known as employment at will. Do you all know what employment at will is? Does everyone know? Okay, so I'll quickly what employment at will is. It means in the United States, an employee can be fired for any reason at any time except for an illegal reason. What this means when it comes to social media posts is that unless there is a specific law that is protecting an employee and their right to post, they can be fired. Sort of the fundamental issue is they can be fired. Now, obviously, losing your job is a powerful deterrent, is a policy issue aside from anti-Semitism. How much do we want employers to be able to control what employees do outside of the workplace? But on the other hand, many of us probably don't want to work with people who are actually condoning terrorism. But on the other hand, we might not want our speech about issues involving Judaism and Israel to be silenced. So how do you sort of address all of this? Now, the way this has been addressed in the United States is there are three types of laws. Okay, there are three types of laws. In the United States, we have federalism. Do you all know what federalism is? Okay, so we have both federal laws and we also have state laws. So we have off-duty conduct statutes. What these statutes say is that an employer essentially can't fire an employee for legal activities they do off duty. And I'll discuss that in a second. Then we have a federal law called Title VII of the Civil Rights Act of 1964. So this law applies throughout the United States. And this law actually requires religious accommodation. But it's not just accommodation of somebody who's a Sabbatarian and needs Shabbat off, or somebody's right to wear a kippah in the workplace. It also covers the right to religious expression. So that's a second type of law, which could protect this type of speech. And then finally, there are what are known as comparator cases. And comparator cases are also under the same federal law, Title VII of the Civil Rights Act of 1964. And what these comparator cases say is that you have to treat similarly situated people the same. So you can't have one rule for Jews, another rule for Muslims. You can't have one rule for Afghans, another rule for Israelis. So these are sort of the three primary laws that have been applying. Now, first I want to mention the off-duty conduct statutes. So the off-duty conduct statutes, about half of the states have some type of off-duty conduct statute. These are statutes that protect an employee's right to engage in legal off-duty conduct. For purposes of this presentation, what I'm interested in is legal expression, primarily on social media, outside of the workplace. These statutes vary greatly. Some of the statutes cover all types of religious expression, all types of expression. Some cover only political expression. Some of them have exceptions for expression which harms the employers. So obviously I can't go through all 25, 26 of the statutes. Since there was a big case in New York State, because I'm from New York, this is a case that was very interesting to me, and it's just a good example of the kind of thing we're talking about. So New York has a law that says employees cannot be punished or fired for engaging in legal recreational activities. For purposes of this presentation, let's think about a legal recreational activity, meaning posting on social media, right? So you can't fire an employee for what they post on social media. We don't want employers to be big brothers. But there is an exception under New York State law that if the posts, the legal recreational activity, creates a material conflict of interest with the employer or really harms the employer, then the employer can fire the employee. So the case I want to mention, which came down a few months ago from New York State's highest court, which interestingly enough is called the New York Court of Appeals, but it is the highest court in New York State, involved a teacher at the Westchester Reform Synagogue, and she's fired because she posted a blog post that was critical of Zionism, and she wrote in it that she, quote, rejected the notion that Zionism is a value of Judaism. Now, she claimed that she was protected because posting that was a legal recreational activity. The synagogue said, look, go on our homepage. You go on the homepage and that's what you see. We support Israel. We can't have a teacher that is explicitly opposing the idea that Zionism is an important part of Israel working at our school. And while the majority decision, it was based on constitutional issues I'm not going to get into, the concurring decision essentially, I think, got it right. Because what the concurring decision said, the judge said that even if blogging is a recreational activity, it's not protected because this type of blogging clearly has a negative impact on the employer. So that's one example of how this is covered. Second example of how this is covered is a federal law, and the federal law is Title VII of the Civil Rights Act of 1964. And what this law says is employers have to reasonably accommodate an employee's religious observance or practice unless doing so imposes an undue hardship on the conduct of the employer's business. And as I already mentioned, the whole idea of religion in the United States clearly includes religious expression. So religious expression, including posting your views on religion, is protected unless it has an undue hardship on the conduct of the employer's business. Now, this I think is a really interesting approach. And the reason is that 3 years ago, in a unanimous decision, this is Justice Alito, which is a little unusual to have a unanimous decision written by Justice Alito, but in a unanimous decision by him, undue hardship was redefined by the United States Supreme Court, and now a higher level of accommodation is required. So now employers have to accommodate an employee's religion, which arguably could include posting your religious beliefs on social media, unless it really substantially harms the business. So I think this is going to be an interesting way that the law is going to go. Now, one interesting issue which has started to come up is that while plaintiffs in some of these cases emphasize that their support for Israel is an integral component of their Jewish ethnic identity, the question then becomes, even if your religion requires you to support Israel and Zionism, does it actually require you to post about it? So that's one issue which has come up. And then, of course, the question is, at what point does posting about your religion actually harm the employer? When does it harm coworkers? When does it harm the business's image? Now, under both of the statutes that I've mentioned so far, the off-duty conduct statutes and the religious accommodation statutes, the question is, when does the speech about Judaism or Israel end up harming an employer's business so it's not protected? It's basically a balancing test, right? On the one hand, this speech is protected unless it ends up harming the business. There's also a third type of case, and the third type of case are the comparator cases, and these are not balancing cases. And in these cases, employees are claiming they're being treated worse than others outside their protected class who are similarly situated to them. And these cases end up involving the tricky issue of what type of speech is similarly situated. And I think in the United States, this is going to end up becoming a larger and larger issue. So one case involved a Muslim Afghan woman. She is the DEI program manager at the University of Minnesota School of Public Health. You can't make this stuff up. December of 2023, she posts this on her private Instagram page. But even though it was on her private Instagram page, obviously nothing you post on social media is really private, and it ended up getting a lot of attention. And she's fired because the university said, if you post this type of a picture, it is incompatible with your DEI role because clearly you can't maintain an inclusive environment. Her response was she was discriminated based on her religion, race, and national origin. And the reason is, she said, that there were professors who were of a different race, religion, and national origin who posted strong and controversial views on Hamas and Israel, and they weren't fired. So that there was a different rule being applied to her based upon the fact of her protected class. Now, the court in this case found for the employer. And what the court in this case said, and I think they got it 100% right, is first of all, a professor is very different than the director of DEI. You have an extremely different role. And second, the kinds of speech professors were posting, while it may have been strongly held views, it was not hate symbols. So she ended up losing her case. And I think in this case, the court really got it right. The case I mentioned at the beginning about Shahadi versus Foley and Lardner, that was a case where you had the Muslim Arab woman who had her job offer rescinded. That case is still in litigation. And it's sort of weird. I contacted the attorneys recently. And they said they really don't understand why the court is not moving forward on this case. But so this case is still in litigation, and this case is a comparator case. And in this case, what had happened, as I mentioned, is that she claimed that non-Arab, non-Muslim attorneys also posted strong opinions about October 7th, and they were not fired. So she lost her job for her posts. They didn't lose their job for their posts. But the kind of posts that she said were comparable were, for example, one partner posted in part, "In every war in the history of the world, innocent people die. That fact, as sad as it may be, has zero relevance to whether the war is justified or not." Now, obviously, I think that is not a comparable statement to actually condoning, to saying October 7th was okay. I don't think that's comparable, but this is in litigation right now. Okay? So just in conclusion, there are these different frameworks. Essentially, the policy question becomes, in all of them, how much do we want employers to control employees' off-duty speech? And then to the extent employers should be permitted to fire employees or otherwise penalize employees who engage in offensive speech, what type of speech about Israel, what type of speech about Judaism, anti-Semitism, is considered so offensive that you should be allowed to fire employees for that? While also remembering there's also going to be the danger that employees can then turn around and penalize employees for their pro-Israel speech. And I just want to end by mentioning a potential concern I've been thinking about a lot recently, which is so far, courts do seem to have recognized that in some cases employers have a right to fire employees who engage in anti-Semitic off-duty speech, right? That they say in these cases, like the one I just mentioned, this actually harms the employer. How can you have a director of DEI posting things like this? It's okay to fire somebody who is actually supporting October 7th. So far, the courts have recognized that employers should be allowed to fire employees for this type of speech. My concern in the United States is that anti-Zionist and anti-Semitic speech, but particularly anti-Zionist speech, is becoming much more normalized. And as it becomes much more normalized, my concern is that courts may begin to say, this type of speech, it's not problematic, it's not harmful, it's just a political opinion, and employers therefore should not be allowed to fire an employee who engages in this type of speech, and this type of speech should be protected. So again, this is what I'm working on now, and thank you very much.